before you go, Misha, go ahead. I have a little bio. I'd like to introduce you. Misha practices law at the Portland law firm of Drummond and Drummond, LLP, where he specializes in estate planning and elder care law. He grew up in Concord, New Hampshire, and completed his bachelor's degree in psychology and political science, minoring in justice studies at the University of New Hampshire in Durham. From there, he moved up the coast to Portland to attend University of Maine School of Law. Misha has been married to his beautiful wife Jessica since 2007, and they live in South Portland with their two daughters, where Misha is currently serving on the city council. This year, Misha has the honor of being selected by the council to serve as mayor of South Portland, Maine. Misha, welcome. So glad to see you, and I'm glad you were able to overcome your technical difficulties. You are now on the air.
Well, thank you. All right, can people see my presentation? Excellent. All right, so as Tony so wonderfully introduced me, I am Misha Pride. I'm an elder law attorney in Maine, and that means I handle a lot of estate planning work. I handle a lot of asset management and preservation work. I also recently, and I don't know if this is because of the pandemic or just because of the times we're in with people getting older, but I've been handling a lot more probate work than normal. And unfortunately, that leads to a lot more probate disputes than normal. And so what I can say is good estate planning can help with those disputes, but having a good lawyer who knows how things are supposed to work helps with it even more. So normally I begin by talking, and I'll start with planning for incapacity, because a lot of people consider, oh, I need a will because when I die, I need to be able to tell where my stuff is going to go. But not a lot of people consider, well, what if before I die, I don't actually have the ability to make decisions? What if my capacity to make decisions is gone? What's going to happen? Who's going to make those decisions for me even before I've passed away? And so I like to take a couple moments to talk about what happens if you don't do anything, and then what can we do to make sure that there are people who are able to help take care of you as you get older. And so what happens if you don't have any kind of plan or any kind of documentation available to assign someone to help take care of you and make decisions for you? Well, there's the court. A lot of people think, well, I have my wife. She's on all my accounts. She can pay my bills. She can talk to my doctors under the surrogacy laws and whatnot. I'll be fine. But you don't know that if your spouse is going to be there when you are finally in need of someone to make decisions for you. And you also don't know if your spouse may, they may be there, but also have those same problems. So if you don't have any kind of documentation or any system in place to make sure other people can make decisions for you, you're going to have to go to the court. And the court can do two things. They can award guardianship or conservatorship, I guess, or both. So three things. Guardians are appointed by a court to take care of your healthcare and make healthcare decisions for you. Guardians can also, if there's a guardianship in place when you pass away, guardians can also, they can make final arrangements for you for a limited period of time, as long as if you have other people in your life that supersede the guardian, then they can. But guardians do have limited power to handle funds. But if you have a substantial estate, then the court is probably going to have to appoint a conservator. A conservator is a person who takes care of money things. For the most part, we think of people who are powers of attorney agents that can do that. But that's only if you assign them. And if you no longer have capacity to sign a power of attorney or sign a healthcare directive, and there's no one out there legally able to make decisions for you, well, the court is the only way to have that happen. And I can't tell you the number of people who come to me who wish their father had come to me and paid a couple $100 to have me do estate planning or just do a power of attorney, and now they're spending thousands of dollars to be able to take care of dad, because it's going to be a court appointed The other thing is this is another cause for argument. If you don't have documentation telling everybody who you want to be assigned to these positions, then the court is going to have to consider all comers. I have been involved in multiple situations where more than one person has petitioned for guardianship or conservatorship of a loved one. And, you know, it can get really dicey. I'm finishing up a case right now where, you know, this gentleman he was 62 when he came to my office, 62 years old, and he couldn't remember what he had done for his 30-year career. And he couldn't remember his siblings' names, except for when they came up in a conversation. And it was his neighborhood friends who brought him to see me because they thought, well, we should get power of attorney to take care of him. We already take him shopping. We already do all these other things for him. But when his sister's name came up, the one word that came out of his mouth, or the one phrase, was, "Oh, she's toxic." And so we petitioned to be his guardian. And his siblings got involved too. And we just knew that he did not want his sister in charge, but there was a fight. And so that was very expensive. But you know, he was only 62 and quite incapacitated and had it was bad dementia. And, you know, so don't wait is the message there, because you just don't know. No one really saw it coming with him. Well, he slowly faded into it, but it was very surprising to his siblings. So if we properly prepare legal documents, we can avoid the need to go to court. So what are those documents? A healthcare directive. This one, I hope, is something that most people have. Doctors are frequently telling their patients to have this done and sent to their office, and I can't do anything but agree. You name a healthcare power of attorney in the standard Maine healthcare directive. This is something that, you know, I do tell people that they can kind of do on their own, but I will say that I had a dear friend, who was very much involved in the hospice community. And every year she would invite me to speak at Healthcare Decisions Day, which is a day in April. And she would set up these booths and tables where people could sit. And I would sit at a table with a bunch of healthcare directives, and I would talk to people about them. And sometimes we would fill them out together, and there were witnesses available, and I could notarize them. And, you know, we got it done. And right at the beginning of the pandemic, she passed away of sepsis. And while she was dying, she was in Florida because she had been on a business trip, and they were going to meet with the ethics panel because they couldn't decide who had power to make decisions for her. She was single and an adult, and didn't have any children, and her parents had her healthcare directive. She had filled out something called the 5 Wishes document, which you may have heard about. She had never had it. She had 2 witnesses sign it, as any healthcare directive in Maine is required to have, but she never signed it herself. Oh. Which, it was very tragic. It was very hard. But she took the decision out of the ethics panel's hands. She passed away the night they were going to meet and decide whether they would be allowed to take her off the ventilator. And so she gave her family that one last kindness. But she's someone who knew what she was doing and was very into this world and wanting everyone to have these documents. And she herself didn't actually sign hers, which is one of the reasons why I still, even though I think people can do this document on their own, I encourage them to do it with an attorney, because when we do our signings, we do them very regimented, and we have a process, and we make sure everything gets signed and everything gets witnessed and everything gets notarized and nothing gets missed. And if it does get missed, we call people back into our office to get it done the next day or as soon as possible thereafter. But we're paying attention to those things when I think busy people in busy lives don't always pay attention to those things. So but you can name healthcare powers of attorney. You can give end of life decisions, and you can nominate a guardian in them. And basically, your agent that you nominate is your nominated guardian for the purposes of any court case to name a guardian. So if someone came in and said, "Well, I don't like that they're power of attorney for healthcare, I'm going to file for guardianship to supersede that." Well, the person you've named as healthcare power of attorney gets priority, when it comes to naming of a guardian. So that's the way your decision is made, and it can be honored that way. You can, and I've seen it done on many powers of attorney for healthcare or advanced healthcare directives. They come in a lot of forms. There's kind of a standard Maine form, but it doesn't have a space for this. But you could also put funeral arrangements on that form, and I've done that for clients, and not necessarily the full funeral plan, but really where to find it. People put their funeral director's number on there, or the custodian of their funeral plans on there, just an address, an email address, something like it. When I pass away, I want my agent to contact so and so because they're in charge of my remains and they have my plan, and we are, that's what I want to happen. And the reason it's there is because we also put instructions for end of life decisions. So when you have these healthcare directives, and if you never want to be on a ventilator, and if you don't want a feeding tube, and if you want to, if you're in a coma in a vegetative state and you want to make sure that you're taken off of the machines and not kept alive unreasonably, those are the kind of wishes you signify in that document. So people are looking at this document near the end of your life frequently, and so having your funeral arrangements or a clue to where to find them on this document could be very helpful. It is not controlling per se. There are documents that you can create under the law. I actually don't know why I didn't create an extra slide for this, but I frequently do a control and custody of remains document. Under Maine law, you can assign someone to have control of your remains, and you can give them instructions on a separate document. It's almost like a power of attorney or a healthcare directive, but it's a wholly separate document. You could also do it in your will. What I'll say about wills, I'll get there, but and if I don't say anything, remind me, but it's not my preference to put funeral arrangements in wills. But that being said, the control and custody of remains document is a perfectly acceptable and legal way of making sure your wishes are followed through with. So the other document you want to have in place to make sure people can take care of you while you're still alive, without having to go to court to get that authority, is the durable power of attorney for finances. This is a document where you name an agent, and that agent can then has the authority, not necessarily the responsibility, but the authority to do what is written in the power of attorney. So most durable power of attorney for finances give a general grant of authority, which allows your agent to write write checks to pay bills from your bank account. It allows your agent to, work with insurances. It allows your agent to qualify for certain other benefits, help you qualify for certain other benefits. We'll talk about that in a little bit. It allows your agent to sell your real property. If you end up in a nursing home or something like that, and you're the last one, and there's no need to keep that real property for some reason because it's just going to be expensive upkeep, then your power of attorney will have the power to sell that real property and put the money in your bank account. I think that's one of the most important things is if you just give the general grant of authority, then really your fiduciary, your agent under the power of attorney, can only do things to benefit you. To an extent, because they can access your bank account, some attorneys do call this a license to steal. And you can make it more so, which is that you can include certain powers, like the power to gift assets of yours to other people while you're still alive. And that can be a strategic thing to do in certain situations. But we'll talk about that a little bit later too. But suffice it to say, you want to choose someone you trust to be your power of attorney for finances. As long as you have someone you trust in that role, who is trustworthy, then things should happen the way you want them to happen, and everything should be happening for your benefit under a power of attorney. You can make them immediate, which means that as soon as you sign it, if someone has that power of attorney, then they can go to the bank and write checks on your account. Or you can make it springing, which means that if you that it is only effective under a certain circumstances. I've had one client, well, most of them say that they become effective when you lose capacity, when you lose your ability to make decisions financially. Your power of attorney becomes effective and your agent can do what they need to do. But I had a client who said, well, you know what? I'm going to make my sister my power of attorney, but I only want the power of attorney effective when my brother writes her a letter saying it's effective. That's a springing power of attorney. You don't have to make it effective on your disability. If you have two siblings who you want to work together, then you can make sure that the one sibling has the power only when the other sibling, says that they do. And that worked out. That actually, I was working with that sister a while ago, and she said, I don't know why my brother was worried. We're always going to work together, but I can tell you why people are worried, because frequently there's a lot of conflict involved when someone loses capacity. And luckily, we do have a lot of families where it's not. So this was one where there wasn't any conflict and everything worked out. But as I said, there are a number of powers you can give under these. The standard powers include powers to deal with real property and bank accounts and whatnot. And then there's gifting powers, powers to change beneficiaries under retirement plans, powers to change beneficiaries under other things. But this is really the sole way that you can allow someone to be on a bank account without giving them, without actually giving the account to them. Some people say, well, I put my son as my joint owner on my bank account, so he can write checks for me when I'm not able to. He'll be right there. I've got 3 kids, and I think my son's the most responsible, so I've made my son the joint owner. Well, unfortunately, what that means is when that person passes away, their son becomes the sole owner of the bank account, and it doesn't have to go through the estate process and be split 3 ways between the 3 children if that son chooses not to do that. Now, in those circumstances, many sons understand and they want to be nice to their siblings, but I've had more than one where we came in and it was a joint account, and the son asked me, well, I'm personal representative of mom's estate and I also have this account. Is that part of all this? Do I have to give that to my siblings, or a piece of that? And I say, well, no, I can't tell you that you have to do that. It is your property. You can do whatever you want with it. And there's really very little the siblings can do. So if that's a sizable account, that's not paying estate costs, and it's not going through and not going to the other heirs. So that can lead to some disharmony. Another way to give someone power over assets during your lifetime is to create a trust where you might be trustee. A trust is a legal thing. It's not really an entity of its own, because it's really a capacity in which you own property. That sounds confusing, but if I gave Tony $50 and I said, Tony, I want you to use this whenever my daughter needs gas. I want you to give her some gas money from this $50. Well, I'll have created an oral trust with Tony. He's my trustee. I'm what's called the grantor, and my daughter is the beneficiary of that trust. That's a trust. It's not an entity of any kind. There's not even a piece of paper that says what the conditions of the trust are. It's an oral trust. And so you could create an oral trust, but the oral trust won't last more than 1 year under Maine law. So you can create a trust in writing where you can actually give yourself property as trustee and say, my bank account is now in my name as trustee, and I am giving myself property, and the beneficiary are me and my wife, or me and my spouse until I die, and then a new person becomes trustee, and there are new death beneficiaries after I die. But if I'm incapacitated, then maybe my daughter becomes trustee in my place. And so that's a way that my daughter can use the bank account that I own as trustee to benefit me, because while I'm still alive, I'm the beneficiary of that trust. And so that's a way in which trust property can be dispersed to me to take care of me, and we don't have to go to court to do that. We just have to have the documents. So then there, so that is also, and we'll talk about that again when we get to succession of property, which is next, passing on your property. And I'm sorry I'm going through this real quick. I guess since I do this in a little bit of sections, I don't know if is it appropriate for me to ask for questions now because we're going to move on.
It's fine, Misha, to just keep going.
Okay,
People can use the chat function to ask questions anytime they want, and
great.
we'll keep an eye on that. But you're doing fine.
All right,
Just keep right on with your presentation.
sounds great. Thank you. So uh, there, the other thing people come to me are concerned about is passing on their property. Usually I'm the one that makes them concerned about having documentation in place that takes care of them while they're still alive. And they're more concerned with what's going to happen to their property when they die, which I think is kind of funny, because people aren't thinking about taking care of themselves, which maybe that says something about the human condition. So in the end, we also end up talking about passing on your property. So because this is where most people are thinking about when they come see an estate planning attorney is what's going to happen to everything after I die. And so in Maine, there are sort of three ways property can be passed on. Well, there's a number of ways, but there's the probate and non-probate are sort of the two main ways. And those ways are governed by, different things. Beneficiary designations are non-probate. Anything in a revocable trust is non-probate, and anything held jointly is non-probate. So if you are a joint owner on a bank account, you're going to get that account without it going through any kind of court process. If you are a beneficiary of a trust and the grantor of the trust dies, you're going to receive property in that trust without it having to go through court. And if you're a beneficiary on someone's IRA, for example, that's a beneficiary designation. You'll receive that property without it having to go through any court process. It all happens by operation of law, somewhat automatically, though less so with the revocable trust. But we'll talk about that one a little bit. If you own something and it doesn't have a beneficiary designation, it's not on a trust and not in a trust, and it's not a joint ownership situation, then you own it and it's going to be part of what's called your probate estate. And that is what your will governs. Now, if you don't have a will, something called intestate succession happens. Again, like the guardianship, your personal representativeship, the person who's going to be in charge of your estate is called a personal representative in Maine. Sometimes they're called an executor in some states. And so that's going to be open to all comers. Now, there is a statute that says that there are certain people who have priority. So your spouse, for example, would have priority to become your personal representative, but they could be challenged by someone. And things in court, I guess, can always be challenged. But if you make it clear in a will, then it's less likely that that's going to be challenged. And if maybe you don't want your spouse, maybe you want your daughter because she's a certified public accountant and she will and you don't want your wife to have your spouse, your wife or husband to have the have that burden, and you'd prefer someone who's a professional doing your estate stuff. Well, your spouse has priority and you can't make that decision without a will. So there is also, without a will, everybody really has a will because the state of Maine has what's called the Intestate Succession laws that says that your spouse receives the first $100,000 of property and then the half of the balance. And if you own a $500,000 house, then that means your spouse is going to $100,000 of it, and she's going to own $300,000 of your house. And then the kids, no matter how old they are going to own the other $200,000 of value. And unless you have a big enough estate where you may be able to make the house the balance of what your wife gets, but then there's a whole bunch of other assets your wife's not going to get. Now, obviously, if you're in a friendly situation, then a lot of the kids sort of they'll give up their rights so that the spouse can get everything. But if you have a split family, and you've got stepchildren, and you've got children, and when this happens, well, this is the children's one shot at the apple. They're not going to be able to get anything if they disclaim their benefit now and allow their stepmom to keep everything. Then they won't. If she decides not to leave them anything, they don't get anything. in a will, we can do things about that. And so in a will, you can have your choice of personal representatives. In a will, you can make a list of who you want to get property of yours. In a will, you can leave things in trust to people. In that same sort of split family where we have, a second marriage situation and there's stepchildren on both sides, there's children on both sides. Well, the first to die can leave everything to their spouse in a trust that guarantees that it'll go to their kids, or a portion of it will go to their kids when they die, instead of everything going to the spouse and then that spouse, in a Cinderella situation, leaving the kids of the first to die out of it. So a will is important in those situations, especially, but I think it's important in just about every situation. You can make a list of how you want your tangible property to go in a will so that you don't have to keep updating your will, which is kind of nice. You can make a separate list and refer to it in your will. That is something that a lot of people are concerned with when they go to make a will is, well, what if I change what if I get a new diamond ring? Well, you can deal with that. New cars, you can deal with that in a separate list that's referred to by the will. So you don't have to keep updating. And you can also make your final wishes known in a will. And I mentioned earlier that I was going to say why I don't think that's a great idea. And that is because wills don't have to be probated until 3 years. Wills have to be probated within 3 years of your death. And frequently people kind of put the financial and that part of things aside to take care of the last wishes of the person. And I know with my grandfather, he had they read his will and looked at it after they had his cremation. They had a cremation. He was put in a vault. It was very nice. He was in the military. They had a full military honors, and then they read his will about how he wanted his his burial to go, and how he didn't want to be cremated. But they read that way after the fact. But fortunately, in my grandfather's situation, he had actually communicated to his wife that he had changed his mind about that. He had just never changed his will. But there was every possibility that he wouldn't have done that. And so he did get his wishes, and I'm happy about that. But there are situations where I've heard that people didn't get their wishes because they put their wishes in their will, and their will wasn't read or reviewed until after the funeral. Another way to pass on your property is through revocable trust. We talked about that a little in terms of giving someone else control of your property while you're still alive. A trust has a trustee and beneficiaries, and there's someone called the grantor, who's the person who gave the property to the trustee to hold on to in that capacity as trustee. And so they can give it to themselves, and then when they lose capacity, they can have a successor trustee come in, and that successor trustee can then manage the estate or the trust estate for that beneficiary until that and for that grantor until the grantor dies, and then that allows the trustee to immediately act regarding trust property and pass that property on to the beneficiaries of the trust after doing some administration, which means an accounting usually of what happened in all the debts that need to be paid with that trust money and all of the other things. The trust gets some administration and then an accounting to show what debts were paid and what's left over for each beneficiary according to the trust, and then they pass on what's in the trust. And so it's very efficient. It avoids the probate process, though I will say in the state of Maine, the probate process is really similar and actually really streamlined. So I don't fear probate as much as other people do, but I do have clients who would prefer their privacy. And if you have a will that says everything I own goes to my trust, then the trust can have who gets what in it. And so wills are posted online. Right now, you can go to mainprobate.net. There's a search feature, and you can, as long as you know the county that someone's will is being probated in, you can click on the county, change it to that county, do a search of their last name, and you can find their estate and you can read their will. So they are public documents, wills, once they're being probated. A trust is not a public document most of the time. And so in a trust, with a trust, you can avoid having that become public. And interestingly, in most wills that I do, it basically says that have trusts involved, the pour over will, that's what that's called, when you have a will that goes into a trust. We still probate the will. Most people don't actually fund their trusts during their lifetime. It's a very weird thing, but they don't. And so all of their property is still going to go through probate. And the will says, everything to my trust. But if my trust would give the property straight to the beneficiaries named in it, then the personal representative doesn't have to hand anything over to the trustee. The personal representative can just give straight to those people. So in those cases, the trust's existence is merely there to name the beneficiaries. The personal representative will still manage everything through the probate process, which involves paying off all the debts of the decedent. It involves making sure that real property is sold if it needs to be sold, and it involves accounting to the final beneficiaries. And so that personal representative appointed by the probate court will just write a check to the beneficiaries under the trust. And it won't have to go through a second process. The trust is just to keep the beneficiaries private and keep the distribution scheme private, so that only the family knows, only the people who are beneficiaries know. So another purpose of a trust is to avoid something called ancillary probate. If you've got a camp in New Hampshire, or a house in Florida, or a house in Arizona or Colorado, and a house in Maine, well, every place that you have real property, you're going to have to do a probate. It's called ancillary probate. Your original probate will happen in the state that you're of your primary residence, and then you'll have to send your will. Your will that was just sent to this probate court will come out in what's called an exemplified copy, and it'll have to go to Colorado, find a Colorado attorney who does ancillary probate, and have them submit that same will to Colorado so that Colorado knows what's supposed to happen with your Colorado real estate. And to avoid that multiple administration in multiple states, a trust will do that, because you can actually name Colorado property and Maine property to a Maine trust, and then the Maine trustee has full power in both places to transfer that property or sell that property as your trust directs after you die. So that's the one time, for most people, I say a trust is somewhat of a luxury, but if you have property in more than one state, I think it's almost a necessity. So that brings me to the sort of the last bit of elder law. I other than the probate stuff, which if people have questions about how probate works more specifically and what happens in probate contests and whatnot, I can certainly address those. But the third thing that I talk to all of my clients about after I talk to them about, making sure we have documents in place to take care of them while they're alive, making sure we have the documents in place to manage the succession of their property after they die, is government benefits, because so many of my clients don't have long-term care insurance. If you have long-term care insurance, feel free to mute your sound, eat a sandwich, and be happy and just be happy, because I can't tell you what a good long-term care policy means to you and your loved ones when the time comes. But if you don't have a long-term care policy, then the state of Maine kind of has one for you, and it's not great because you have to spend a lot of money to get there. Because the thing that people don't really know is that there is, other than private long-term care insurance, there's no coverage for true nursing home care or assisted living care through Medicare. Medicare, which most people get at age 65, though you can get it earlier if you're disabled after 2 years of disability, will cover a lot of different things. Parts A and B cover doctor's visits and some home health care stuff, and durable medical equipment and transplants. In fact, it's interesting that Medicare Part B actually still covers the drugs that you get if you get a transplant, because we covered transplants through Medicare before we had Part D, which is the drug benefit. And so even the durable medical equipment, is covered there, and home health care is covered through Part B. And it's mostly, I think, covered in there because that's, those people with kidney issues that have to, deal with machinery and whatnot. That's all covered by Medicare Part B. And so, and infusion things like that, nurses coming into the home to do infusions, that's Medicare Part B. Part A has what's called a skilled nursing facility benefit. That is where people think, oh, if I need a nursing home, Medicare covers that, right? This entitlement that I have. And the skilled nursing benefit is somewhat of a misnomer. It is skilled nursing care. It is, but it's 100 days, and it's really for rehab. It becomes effective when you've been in the hospital for 3 days or more. They will then, if that's for, say, a hip replacement, and then you need to rehab after you've had your hip replaced, Medicare will cover that. There's a co-pay scale that increases as you get closer to day 100, and if you get to day 100, and that's an if, then they will kick you off. And if you are unable to go home at that point, you will be in a nursing home and not covered by Medicare, and you will have to pay privately for that unless you have long-term care insurance. The other piece to that is that they can kick you off sooner than 100 days if they think that the care they're giving you is not actually increasing your, beneficial to you, if it's not making you better, if the rehab isn't working. Now, there's some advocacy here that can be done. There's a great nonprofit, the Center for Medicare and Medicaid Advocacy, that steps in a lot in these type of cases because there's sort of a misunderstanding about the standard that's necessary. For a long time, they needed to see improvement to keep you on this skilled nursing care. And in 2013, there was a case in the Supreme Court that basically said, even if the care is just slowing your decline, it's still coverable by Medicare, and you should keep going. And that's something that a lot of doctors, nurses, and social workers don't know. So if you have a loved one who is going through the skilled nursing care benefit, and they're starting, their team is starting to talk about a nursing home before the 100 days is up, it's a good idea to sort of talk to either a lawyer or find out from the Centers for Medicare Medicaid Advocacy, which is based in Connecticut, but they have offices all over, and they will help people in Maine. It's a good idea to talk to someone there about what are my options for advocacy in this place, and how do I find out whether they're making this decision based on the current standard or the old standard. So just a sort of issue to look for. But once you're in a nursing home and you're paying privately, as long as you have over $10,000, you'll have to continue to pay privately. That's known as the spend down. That's $10,000 to your name. Your spouse can have a further $130,000. So really the effective amount is $140,000. Now, if you're married, 10 if you're not. And it doesn't include your house, and it doesn't include your car, and it doesn't include a prepaid funeral plan, and it doesn't include certain vehicles, retirement, like annuities. Talk a little bit about that, but really, like, your IRA and 401k are fully countable as assets. So if you have more than $10,000 to an IRA, not only are you going to be paying most of that over to the nursing home because it's going to be $10,000 to $15,000 a month for your care, but you're also going to be paying taxes on all that. Now, that'll be reduced by your medical care, but still, that can be a really scary, frustrating time to figure out exactly what to do in those situations. So Medicaid, after you are below their means test, their means standard, which is $10,000, as long as your monthly income, most people that's going to be just SSDI, is below the amount that it costs to cover a room for a month, then Medicaid, Maine Care here in Maine, will start covering your long-term care. And your spouse can have $130,000, which isn't actually that much these days because they may have medical problems too. It also covers assisted living care under a similar standard. And then there's, there are other benefits to look at. I'll just briefly, most people are getting their income through SSDI, which is Social Security Disability. And then there's what's called Supplemental Security Income. That's typically for disabled folks who have been disabled since they've never been able to work. And that has a much stricter means test of $2,000. But I talk about that briefly just because another thing that I do for some people is I create special needs trusts. So if a spouse needed long-term care, I work with clients to help them protect assets, because as part of the spend down, you can pay a lawyer. And as part of the spend down, you can do a lot of different things to invest in certain vehicles that could protect your assets. You also could have another kind of trust, but that's a sort of a longer story, that sort of pre-plans for that potential of Medicaid. And one of the problems with Medicaid eligibility is a gifting problem. You can't give gifts to your loved ones to become eligible. So within 5 years of seeking eligibility, you can't give any of your money away. So you're stuck with a lot of money, and you and your spouse are maybe stuck with a lot of money that you have to pay to the nursing home. Well, when I work with clients, we use certain annuities and other vehicles that are you can use certain annuities and other vehicles that are not countable, like your house and your car and your burial plan. Those aren't countable assets towards that 10,000. You can use certain annuities to make it has to follow certain rules, which is why you need a lawyer to make sure the annuity follows those rules. But as long as the annuity follows those rules, you can actually invest in an asset, take your money and put it into an account that pays an income stream that makes it not countable. Now, when you've done that, you're going to be benefiting your spouse. So most of the time, if you're the person going to the nursing home, we can do a lot to save your spouse's money. Well, what if after we've done all that to save most of the money in your spouse happens to be the one that predeceases you and leaves all the money to you in their will, everything to my spouse when I die. Well, now we were back to the same place we just were. All of the money that was was protected because we were able to help with the spouse now goes back to the person who was in the nursing home, and that person will then have to spend it down. You could say, well, I'll just leave it to my kids. Well, spouses have certain rights, and the state of Maine is going to make sure that the spouse gets as much money as possible from that estate. So there's another way. And that is, in your will, you can set up what's called a special needs trust. That could be the receptacle and benefit your spouse, but not be countable. So all that money we were able to save with the spouse can now be passed to the trust. The trust can benefit, but doesn't have to spend the money on the surviving spouse. And because of the way the laws are currently written, enough of that money counts as going to the spouse, even though they get none of it, that it actually abrogates those issues about the spousal rights to what's called the elective share. So you've now passed everything to basically a special needs trust that's kind of a holding tank for money that can now just sort of hold on to it while that spouse is in a nursing home, and then when that spouse dies, it can go to the kids. So just one more way to sort of protect assets. I know it's very complicated, and if you're interested in that kind of thing, please come see me or another lawyer, because I think this is one of those things that far too few attorneys do, and far too few people do, as consider these things. So that is what I got. I'm happy to answer any questions, and yeah, thank you very much for having me.
Misha, thank you so much for that incredibly compact presentation. I'm very impressed. People, you can use the chat function to ask Misha questions if you wish. Or Misha, you should probably leave the screen sharing now.
I'll try to figure out how to do that. Maybe if I just close it.
If not, I think there we go. Okay, excellent.
All right.
Well, Anybody have any questions for Misha at this point? We have
I
just,
do.
yes,
I'm,
go
I'm,
ahead.
I'm glad to
Please,
be here.
Rebecca.
So when I have a trust,
Mhm.
and I did it before my daughter was of age, and now I need to, get rid of the stuff that says who's going to take care of her if she's, if we die before she's old enough to take care of herself. And I probably also have another account to add. Is it, do I have the way you described a trust at the beginning, the way you could just say it or you could write it down, can I just amend a trust myself? Can I go into those documents and scratch something out and write something on? How does that work?
So once a trust has been written, it's basically a contract. Now, you can't to amend a contract. You can't just go in and scratch things out. You have to do a trust amendment. There is, however, a way that you can do. It's called an amendment and restatement of that trust. In which case, you kind of start over again. You amend it by deleting the whole thing and replacing it with something new. So either of those things can work. If you have access to the Word file of that trust, then you could amend it, restate it very easily. But the issue is you have to have it re-executed. You have to execute that trust with the same formalities that were required to execute the original trust. At least in Maine, you do. But I know that you can't just scratch things out on a trust. A will is a little different. That while I don't encourage this, technically, if you sign the places where you make changes in a will, you could scratch out portions of it and replace them with your own handwriting. But again, I don't encourage that either, because that can cause lots of issues. But a trust is a contract, and so you can't just scratch things out after it's been executed. Once it's been executed, it is the governing document. And so in order to make changes, you need to do an actual written amendment, or an amendment and restatement that would replace everything.
And when you say it has to be executed, that means an attorney has to sign it, or
No, I mean, I don't know what
what
the
does
formalities are in
execution mean?
California. Yeah, execution means signed with the formalities necessary for the state that you live in. So in Maine, a trust just needs to be, well, a trust really just needs to be witnessed, but we usually have them notarized too. And in Maine, you could probably get away with one witness, but again, we're careful because we don't know where our trusts are going to be taken after the fact, and it's easier we have them as with as many formalities as possible, so that if you take it to Florida, the Florida court or whatever doesn't have to check with Maine, because guess what? It was executed with the formalities that Florida requires, which is 2 witnesses and a notary. So that it whatever formalities it was executed with, signed. Execution is you signing it. Whatever formalities were done when you originally signed it probably need to be done with any amendment to that trust. Yeah.
Any other questions for Misha or statements?
Here I am, free legal advice.
A rare occurrence.
Yeah.
I just appreciate that you've raised the issue of disability, and that we think about not just our death, because that's what we talk about a lot in this organization, but also that we need to think about how to take care of ourselves beforehand. That's a very helpful point that I'm glad you raised.
Thank you.
Anybody else? Well, Misha, you've certainly done
Donna,
a
you're
wonderful
muted.
job.
Donna started
Donna
to talk, but she was muted.
Who was talking?
I had a question about
Okay, please go ahead.
if I'm married and my husband were to pass, and we do have a will, but I was thinking that while I'm alive, that what was his is mine. Is that wrong?
Well, it depends. That's a favorite legal answer. It depends. If we're talking about tangible personal property, then probably, the stuff in your house, probably belongs to both of you, and everybody probably understands that. But if he had a specific collection that he promised to someone, that could create a dispute. But
I was thinking of like stocks and bonds and stuff like
okay,
that.
so that will depend on how those, how his accounts are titled. That is one of the most important things when figuring out what happens when someone dies. How are your accounts titled? How is your house titled? Is your house titled as joint owners with rights of survivorship? Well, that's the answer. Then you will have it via, you will own the house via right of survivorship. If his stock accounts are titled just to him, then they may be part of his probate estate. But he could also have transfer on death beneficiaries on those stock accounts, in which case they would immediately be transferred to you and not be part of his probate estate. So it's really how they're titled and if they have beneficiaries or joint owners on them. Those are sort of the questions you need to ask the people who are custodians of those accounts. You know, if you have an Edward Jones guy or Ameriprise or any of your financial advisor people, or sometimes it's the people at work who are the custodians of the retirement accounts and whatnot. So.
Any other questions for Misha? Free legal advice, your last chance. Well, Misha, thank you so much, and I'm sorry you had a stressful morning getting set up, but everything worked out beautifully in the end. And for those of you who wish to communicate with Misha directly, he is at Drummond and Drummond in Portland, Maine, and I'm sure he'd be glad to meet you face to face. Thanks, everybody.
Thank you.
Thank you.